So we are live here, estamos ao vivo aqui. Boa noite a todas e todos. Obrigado pela presença. Good evening and welcome here at Tapera. We are a non-profit institution. We're glad to have you all here. A Tapera é uma instituição sem fins lucrativos e a gente está muito feliz de receber vocês aqui. Eu vou passar a bola aqui para a Michelle, que vai fazer a introdução e os debates. Obrigado.
Boa noite a todos e todas presentes. Obrigada pela presença. Eu queria explicar para vocês, inicialmente, nós contamos aqui com 2 estrangeiros, a professora Viviane Bath, da Universidade de Sydney, na Austrália, Manu Misra, pós-doc na Escola de Direito da Fundação Getúlio Vargas, aqui em São Paulo, mas originalmente da Índia. É um grande prazer tê-los conosco, mas isso vai nos conduzir a um debate em inglês. Espero que isso não seja uma dificuldade para quem estiver aqui, quem estiver acompanhando pelo streaming, mas se houver, enfim, fiquem à vontade para interromper, pedir esclarecimentos, ou uma parada, uma retomada, e a gente faz isso para que o debate ocorra da melhor forma possível. Sim, também as perguntas, se vocês preferirem colocar em português, a gente pode fazer a tradução aqui para o grupo. Well, so good night for everyone, and thank you so much for Tapera having us here. It's an important moment to me and Fábio to have the first moment of discussion of our book here in Brazil, in São Paulo. And having with us Professor Viviane Bath was part of this project and worked very well with us, and we are also developing other projects together. And Manu Misra, who is also attending from abroad here for a postdoc program, and will join us in this discussion. And also for Professor Adriana Schor at the Institute of International Relations at the University of São Paulo, who is also a person that we also would like to discuss these topics and had in fact, in past discussions, also highlighted important points to our work. And Eli Caetano Xavier, a professor at the Universidade Federal Rural do Rio de Janeiro, and who is a pleasure to have you, one of the brightest young researchers in Brazil, who is doing a serious research on international investment law. So all this group is all engaged in a common field of international economic law that we work together. And this is the way that brought us here, Fábio and I, with this project. We would like to comment on a little bit on that, because we started this project, we were colleagues first, we had the chance to be in common academic opportunities in Brazil and abroad. But then we were like professors teaching in Brazil in the 2010s, and we started discussing how hard it was to teach Brazilian students international economic law. That was a new field on international law that started discussing the economic relations of the states, but very much based on a literature that was developed abroad, mainly in developing countries, in central economies. And we thought, so how can we work on that? We were developing cases to teach our students, but at the same time, we thought it would be important to develop a work that could bring us to an international discussion and bring new ideas to this field, new problems, new concepts that we could be developing together. So this is the way that brought us to this project, and then we gratefully had the chance to invite people like Viviane, who is based in the University of Sydney in Australia, James Nedumpara, who is a professor at Jindal University in India, Professor Rodrigo Polanco, who is originally from Chile and now based in Bern, in the World Trade Institute, Professor Maliba King Foreri, who is in South Africa. And so all of us, we started then, we chose the idea of discussing the international investment regime. That was a regime that was under debate globally, thinking what were the difficulties of this system mainly for developing countries, but also other rules that were bringing difficulties for countries such as Australia that has a developed economy, but could not really implement its domestic policies and was facing also the hardness of being changed by private actors abroad. So this movement in the international arena is what Fábio will mention or point some of the most relevant points to us. But this is what we were very happy then to develop as from 2014 together in other different meetings and working together on the papers and commenting on each other papers to develop these new chapters of this book that are registering the history of each country in dealing with international investment regulation. What were in fact, the goods and the bads that this system brought to each country, and having all these chapters in one book and under one idea, that is the idea of reconceptualizing international investment law from the global south, did not mean at all that all those countries were going in the same direction, and did not mean, intended even to mean that they should be. The idea was really to bring the different stories and to let us be aware how much the stories can be different, and each country can be challenged in a different way, domestically and internationally. So I'll pass then to Fábio, who will comment into the details about the regime, and then we will invite Viviane also have some points about the book, and then we invite the commentators to bring their ideas to us. Thank you.
All right. Good evening, everyone. Thanks, Michelle, for starting the discussion of this book. So as Michelle was telling, I think the story also has to do with how we see ourselves in academia and what type of academia we want to be doing. And this, I think, has it deals with the story of how international law can be done differently from depending on where we are. And I think in the bottom line, it challenges the idea of universal international law. So we're, as Michelle was saying, we're looking at the different histories of international law and arguing that this is also international law and that this needs to be brought to the broader debate. So how we approach the project, so we have all these different countries and we were working together, and the project came about in a period where international investment law is living in what the scholarship calls a crisis, a legitimacy crisis, right? And then what are the elements of this crisis? So we start by identifying the elements of the crisis, and I basically we identified at least three of these challenges. One is this controversial nature of international investment agreements that unduly protect property rights at the expense of the right of the host countries to regulate in the public interest. And we have several examples of such, let's say, problematic areas. Australia has one recent case involving tobacco. South Africa has a case involving redressing of past legacies of the apartheid rule. And as we look into different countries, we find these different narratives. Another element of identified as this crisis is the demands for a more balanced approach between investors and states, and this balance would be focused on imposing more obligations on investors because the regime was built around this idea of protecting investors and not really thinking about the responsibilities that these investors could have towards the host states. And then finally, another element that we discuss in the book is concerns the idea of investor-state dispute settlement, a very debated issue, and especially these days when we're thinking about other alternatives on dispute settlement. So if you think about this investor-state dispute settlement, that is one of the core elements of the regime, you think about the disparity of treatment between foreign investors and domestic investors. You think about arbitrators' bias, lack of arbitrator accountability, lack of transparency, absence of amicus curiae and third-party participation, inconsistency of awards, and so forth. So facing this crisis, countries are promoting reforms. Some of them are promoting reforms, some are promoting changes, but others are trying to maintain the regime as it is and only promoting more cosmetic changes. So we look at this, starting from this problem, we look at the responses that are out there. And of course, the traditional suspects, right? The more powerful countries like the US or even the European Union, they have been working on these, let's say, reforms or proposals. But then we wanted to unveil different stories, as we said, and then we wanted to unveil these different narratives, right? And as Michelle pointed out, this is because we're talking about the global South, it doesn't mean that there is only one story there, right? I mean, we have different countries, these countries have different histories, and they want different things from this regime. But in the project, we were able to identify some commonalities that these countries share. So, first of all, they even though they're motivated by different drivers of change, they seem to be discomfortable with these claims brought against them as states by foreign investors, because, as you know, this compensation might be really, really high, and that's a problem for every country, but especially for developing and poor countries. And above all, they're concerned about these limitations on their right to regulate in the public interest. So in face of that, they have developed some, let's say, answers to the regime or some proposals of change, which deals with this topic of where do we see change really originating from the global South, and that's what the book is all about, right? So we identified two arenas of change that these countries are promoting. The first one is this general search for more policy space, and then countries are doing it differently. But there is this common core between all of them. So it could be through a more, let's say, limited definition of investors or investment, cutting back on some of the standards protections for investors, defining new rules on expropriation and standards for compensation, and also promoting rules or exceptions to the rules of free transfers of funds, especially for balance of payments issues. And then I think one of the very interesting area of debate in this regime, the investment regime, is how these countries are also rethinking the dispute settlement system that each one of them have been using. So you have a variety of countries, as we mentioned, in the global South. So, for instance, Chile is one example where there isn't much change going on there, and there isn't much change coming from Chile. So basically, the country seems to be fine with the standard model of investor-state dispute settlement, or whatever other model that other partners such as the European Union might propose to them. But then you have some other examples in the global South that are thinking differently in terms of how disputes should be settled. So, for instance, Australia, with Viviane, will have the chance to talk about it, but it seems to be more case by case. So it's not necessarily ISDS. But it could be eventually. South Africa that has opted for using local courts and no longer arbitration. And then we have this Brazilian model that opts to use preventative mechanisms, but also state-to-state arbitration. So in conclusion, we see that differently or unlike the traditional argument that, you know, change or experimentation takes place in the global north, I think the point we're trying to make here in the book is that there's a lot of experimentation in the global south as well, and we should also look to this experimentation in terms of building and rethinking the global regime, right? But of course, there are some problems with these alternatives, right? Because after reading the book and after working in the book, I think one question that might be legitimately posed is, okay, to what extent these changes are really going to be implemented, and to what extent that these changes are workable or feasible, right? Or isn't it just a group of, you know, crazy countries that are trying to think differently but have no agency to promote effective change, right? So one issue is agency. So to what extent these countries can effectively promote changes in the international system, and how they will promote change in the system. Okay, and the second one is has the second, let's say, point or limitation has to do with timing, right? So is it the right timing for change? From the perspective of what is happening in the world today, and then I think I'll leave you with this more like irritations, right, of the regime, and I'll pass the word to Viviane, who can complement or say something about the project. Thank you.
Okay, thank you, Michelle and Fabio. I was very pleased to be invited to join this project when we first got going, and as we extended our scope and our countries, we moved on not just from the BRICS but also to Australia and to Chile. Of course, Australia is not in the South-South context, but it is in the global South. And I think it was legitimate to add Australia because, in fact, Australia is a producer of commodities. It's a producer of natural resources. It's a very large country which has attracted the second largest amount of Chinese investment behind only the US over the last 10 years, since really China has begun to invest. So it does have many of the same issues that, in fact, countries like Brazil and South Africa and India have, not to mention our own very interesting investor-state arbitration. So I wrote the chapters on Australia and China. I should say really that when I was in practice for a long time working in China, which is where I first became interested in Chinese investment. And to do those chapters, it's necessary to look not just at the way in which those countries deal with bilateral investment treaties and international investment law, but how they also deal with their domestic regimes. So one thing that the book covers also is what are the domestic regimes, how do these tie in with international regimes, and how do we preserve the necessary flexibility to modify domestic regimes in order to protect our own national interests while still remaining consistent with our international obligations. And in this regard, I think China and Australia are both very interesting examples. China, for example, after it opened up in 1978, opened up to foreign investment very cautiously at the domestic level, but at the same time it also started to sign bilateral investment treaties from the mid-80s, with which it was also very cautious. So a feature of Chinese policy in relation to both domestic inbound investment initially and then to bilateral investment treaties was the great discipline with which it made sure that its domestic and its international policies coincided. And in a way, if we look at all of our examples in the book, this is really quite remarkable, the consciousness and the discipline that the government actually had to keep these things consistent. Now, this worked very well for China until it got to the stage where actually Chinese companies wanted to invest abroad. And at that stage, of course, China discovered that the very cautious approach to its international obligations was no longer so advantageous, because even though it had made sure that foreign investors were very unlikely to bring a case against China because of the limited protections which had been provided to them, it now meant that Chinese investors had very limited abilities to actually bring or to obtain protection under the international investment regime when they started to invest abroad. And so this meant that the Chinese government had to both relax its policies in relation to inbound investment in order to make sure that it could relax or ask for essentially a higher degree of protection for its own investors going abroad. And again, the Chinese government, one of the advantages, I guess, of being an authoritarian government, was able to deal with this with a great deal of discipline to actually start renegotiating its treaties with European states, in particular, in order to obtain and to give a higher degree of investment protection. Now we're into more of an experimental stage because Chinese investment outbound now greatly exceeds investment into China. And so the question is what the Chinese government wishes to do or what it can do in the area of international investment. And this is becoming quite an interesting question as it becomes more of an actor at the international level. But there are, I think, a number of very interesting points also about the way China behaved, which is China, of course, was, may still be, a developing country. And it's always seen itself very much as a leader amongst developing countries. So when it was signing investment treaties in the 1980s, in the 1990s, it was very careful to present itself always as conscious of the issues of other developing countries and as anxious not to override the sovereignty of developing states. And if you look at all of China's rhetoric in relation to its outbound investments even now, it's always talking about win-win cooperation, the importance of reciprocity, the importance of two-way investment, and so on. In fact, however, if you look at China's investment treaties, China has very much taken on the traditional model of investment treaty that Fabio was talking about. Although there are some modifications and adjustments to deal with, say, developing country interests, or indeed China's own interests, to make sure that China is protected, it really has always followed, from the time it first started signing these treaties in the 1985s, the traditional developed country model of treaty. So the question is, as it moves sort of towards 2020, the extent to which it's prepared to move towards the US model, which is the most stringent of the bilateral investment treaty models, or whether it's not prepared to take those final steps. So Chinese treaties on the whole do have an investor-state arbitration clause. The earliest ones had a very limited clause which limited the amount of limited the subject of the arbitration to the quantum of expropriation, but more recent ones cover much more extensive ground. In the treaty with Australia, there are significant modifications in place essentially to deal with the question of regulatory space, which is something Australia is very sensitive about. And China is prepared to be accommodating with that. But essentially, it's still what we're talking about is investor-state arbitration. And of course, ironically now, China is finding that all of its very limited treaties from the 1980s and the 1990s are becoming a problem because as part of the Belt and Road initiative, China has a lot of bilateral investment treaties in place with many of the developing countries along the Belt and Road, but most of those were signed in the 1990s. And so China's ability to actually successfully get protection under those treaties is extremely limited. So it's a very interesting time in terms of China's policy in relation to international investment. And although we didn't get, this all hadn't happened at the time we wrote the book, Michelle and I, in our latest project, are looking now at sort of China in the international sphere and the sort of moves that it's making. But again, I should emphasise that this is still in the context of the traditional structure. And certainly in its treaties with countries of the South, China has actually not made very many modifications to refer to differential treatment, for example. Its treaties are almost all reciprocal in nature. It rarely refers to environmental issues and to other issues of those kind. So if you looked at them, you would not think, in fact, that China was a leader of the South, as it purports to be. Now, I think briefly to sort of go to Australia. Now, Australia is, of course, a developed country. But I have to say, in terms of its policy in relation to bilateral investment treaties, I think we have about 20 now. Well, actually 19, since India and Indonesia have been terminating them. If you looked at our bilateral investment treaty program, you'd have to say that it really looked as though someone went on a holiday and decided to sign a bilateral investment treaty. There weren't very many with them. The vast majority of them were with states with which we had very little in the way of trade or investment. Estonia, for example, is not and is never likely to be a major partner of Australia. So the only important ones really were with China from 1988, when I think a president came to Australia for the first time. Indonesia, which has now been terminated because an Australian investor brought a case. India, also terminated. India does not love us anymore. And all of those were fairly plain vanilla types of treaties. And no one really paid any attention to them or thought that anything was going to happen until Philip Morris reorganised its corporate structure to make it possible to bring a case against the Australian government because of the Australian government's tobacco plain packaging legislation. Now, I think we'll talk about that one because it's actually probably the most interesting thing that's happened to Australia for years. I should say we do now have free trade agreements in which we do have investment chapters, and as a consequence of this investor-state arbitration, the ISDS provisions are very carefully negotiated indeed. But what this case was about essentially was that Australia, as a consequence of the World Health Organization recommendations, announced its intention to pass legislation whereby any cigarettes in Australia had to be wrapped in a rather ugly brown paper package on which would appear a very large picture of someone with cancer of some kind, say a diseased lung or a mouth with the teeth broken out, something like this, and a large health warning. And then on a very small part of the remaining package, you would be able to put your brand. So say it was Rothmans, you could put in plain letters only the word Rothman. You could not use the logo, you could not use the script, you could not use any of the pretty pictures of the Marlborough Man or anything of this kind. Now, the announcement that this legislation was going through was made some time in advance, and prior to the time it was passed, Philip Morris reorganised its operations so that the Australian operations were held by the Hong Kong company, which is Philip Morris Asia. Philip Morris, I should say, is organised in Switzerland, and Australia does not have a bilateral investment treaty with Switzerland. So the Philip Morris appealed to the High Court of Australia on the basis that this constituted expropriation and lost. So they then brought the investor-state arbitration in Hong Kong under the treaty, claiming that expropriation had occurred because the brands could not be used. Now, I suppose we can go straight to the happy ending, which was that Australia won. The point is that the arbitration was brought in about 2012. The result did not come out until about 2016, by which time, by some estimates, about $50 million in costs had been incurred. At the same time, there are also 5 WTO cases going on in relation to the plain packaging. Now, as you can see, this gave Australians generally quite a dislike for ISDS. In fact, I think you could say that the reason ISDS is unpopular everywhere follows a time when a case is brought against our country, since our country is always right. So since that time, Australia has been drafting it with severe limitations, and I know that it's probably my turn to stop. But I'll just mention that the China-Australia Free Trade Agreement, the investment chapter has almost no substantive provisions at all because they have yet to be negotiated. But the dispute settlement section goes on for 18 pages. And what it does essentially is make it possible for a government to issue what's called a social welfare notice, which says that a matter is a matter of social importance to the host government. And if that is the case, then essentially the ISDS cannot proceed. It also has various provisions in it pursuant to which the two governments involved can agree on an interpretation of the treaty. Because I think in most cases it's generally true that both the host government and the home government are quite often prepared to limit the scope of investor-state arbitration. It's generally the investor which is not prepared to do so. So I think I'll stop talking about my chapters at this stage, and who are we moving on to? Eli.
Eddie? Okay, so I give the word to you. Thank you.
Thank you, Michelle and Fábio, for the invitation to share this debate with you. I have the very comfortable position of being a commenter. I read the book enthusiastically, and as a reader, some of the merits of the book were already stressed by Michelle and by Fábio, but I think I should nonetheless highlight some of the aspects. The first thing that this book treats is the reform of investment regime. This is precisely the hot topic on international investment law. So anyone who is dealing with this topic will face the debate on a reform or the way of reaching this reform, even though we might debate which kind of reform are we pursuing. I think that Chile, which is one of the countries selected in the book, is somehow trying to reform its agreements under a concept that the UNCTAD has of reform, of crafting or trying to refine the language of the treaty, only by refining the language of the treaty. And Argentina perhaps is pursuing the same alternative of just refining the language of the treaty, even though this refinement of language is much influenced by northern countries. And there is little, I think, and that's one of the questions I'd like to raise, how much of the reform is really coming from the South and how much is inspired by what is happening in the North. The second merit of the book is trying to escape the cliché or the truism of concentrating only on what happens in the North Atlantic, what happens in Europe, what happens in the United States, what happens in Canada, I'd say. I'm not saying that we don't have to study these countries, but what I'm saying is that if we are scholars from the Global South, we have necessarily to deal with our ideas of the South. And that's the second merit of the book, escaping the truism of Global North. And the third merit of the book, for me, is giving a deep analysis of each country. You are not going to find superficial analysis in this book. Each chapter has a very deep analysis of the political, of the normative, of the social, and of the economic constraints that led each one of these countries to choose one way for the reform. That being said, I have the task to raise some questions for the debate. And the first one, one idea that was very clear when I read the book is the fragmentation of positions. Trubek recognized this fragmentation in the last chapter of the book. Each one of these countries have sought to find your own way in the reform. And my question is, should we find a common sense in this reform? Do we need to build a South consensus? Is that desirable? Is that needed? We have to recognize that every country has its own interests, and that reflects in this fragmentation. But the question is, if we want to really have a global reform, those ideas developed in the South must go beyond the South. And how are we going to achieve it? How are we going, the Southern countries, to achieve this centrifugal force of the European Union with the investment court system, or the centrifugal force of the United States with a TPP-like model, I mean, even though we have the Trump factor. So how are we going, the Southern countries, to face this centrifugal force of the North if we are not able to build a consensus among ourselves? We might think about the Brazilian proposal within the WTO, the General Council, for discussing an investment facilitation agreement. We have the G20 principles, which were led by China. We had the guidelines made by BRICS. I mean, we are, to a certain extent, trying to find a way to build a consensus. But which consensus? That's one other question. And the second question I have, or the second point I'd like to stress, is how representative are each one of these ways that we find in the book. I mean, we have countries like Chile and I would say also Argentina, who are still signing BITs with language refinements. We have countries like South Africa, I would also say Ecuador and Bolivia and Venezuela, who have dropped from the investment regime and are relying on domestic regulation. We have countries like Brazil, which are relying still on international agreements, but on a very particular version of investment agreements. We have China and perhaps Australia, who have very pragmatic case-by-cases position when they negotiate investments. So which way of this one we should follow? And perhaps the question is, what reform we want? What's the concept of reform? Is reform rebuilding the guidelines and the principles and the values of investment protection? Is not thinking about investment protection anymore? Or is it just changing the language of the treaty to respond to the challenges that come with arbitration? Another point is what is our enemy? What are we fighting against? We are fighting against arbitration. That is what seems when we think about the white industries case in India, which was the driving force for the reforms in India. We have the forest case in South Africa, which was the driving force for the reforms in South Africa. We have the first case of France. We have the first case of Austria. We have two first cases of Italy in the recent years, and those were the driving forces of what we call now reform. So it seems that arbitration plays the central role in driving the reform. So are we going to fight arbitration? Is our ISTS our enemy? Or are we playing Don Quixote with an imaginary monster, and the monster is bigger than just arbitration? Is the agreement as a whole, or is the system as a whole? So that's another question I'd like to stress. And last but not least, the role for China. I mean, the last chapters of the book recognize that China will play the central role in defining the future of this reform movement. And as far as I have understood from the book, China is very comfortable with the rules as they are now. So if we are going to rely on China for leading us in the reform, probably we're not going to have a reform at all. So what we're going to do?
Thank you, Annie. I think we are collecting the comments and then we give a word to the authors.
Thank you. First of all, I would like to thank Michelle and Fábio for inviting me here. And I'm a person outside the field. I am not an international lawyer or do not study law at all. But I'm very interested in international relations and economic laws and the way public policy is being motivated and it's been changing. And first of all, I'd like to congratulate Michelle and Fábio for doing a great empirical work. We've been talking, Michelle and some of my colleagues from the law field here in Brazil, and they are always complaining that, oh, we don't do a lot of empirical work in Brazil, and how hard it is to convince our colleagues from law schools that empirical work is something that it's worthwhile to do, and it can help us to understand the way law changes and how we apply it. And I think, congratulations, you could finally give us a product of very good empirical grounded work. And it's amazing how I know it was not easy to convince people that you can do it in law studies. The work convinced me that there is in fact some innovations on this treatise, and the direction is trying to reduce the asymmetry between the investors and states in protecting their interests. The chapters were fully grounded in empirical evidence, and I was convinced. But I have, since Michelle asked me to make some comments from the international political economic perspective, I have two points that I would like to hear from you. One of them, Viviane, just said something that it made me think that maybe we should ask the distinction between North and South and the distinction between developed and developing country. During the book, sometimes I thought that, well, it's the same thing. When you say South, you say developing. When you say North, you say developed countries. But in other parts of the book, then I said, no, it's not like this. There is a distinction between developing and developed countries has something to do with income, and North and South, there's much more than income. There are some characteristics that we can put Australia in the global South, or we cannot put like South Korea as, we can say that it's a developed country in the South. And how we deal with this, and why I think this is important to have at least an agreement if the vision from the South, it's something that it's different from the vision from the North, and what North and South really mean. In the beginning of the introduction, the story that is being told, I think I'm stressing a little bit, but pushing hard, but it's saying that the stories, there is, the North is promoting a neoliberal international order, and the South is in a movement, it's a concerted movement in offering a new international order. And it is like saying that I know you stressed the saying that not all the countries are going the same way, but it seems to me that you are trying to make a case that the motivation is this one. And motivation is a very hot topic in international political economy. And you, in the sense that it's very hard to find and to explicit understand what the motivations are. And I know that the book was not designed to fully answer, but since it seems to me that the story behind the case studies is this motivation in making a statement saying this international order does not protect our interests, and we are going as a group moving forward. And I have some problem with, I think, the OIP students and thinking about how you can put motivation for public policy changes in a government during such a long period of time, and saying that government is not, a state is not monolithic. You have different group interests in different moments of time. And what I see is that the North, like the US, the first bilateral investment treaties, they were designed to protect much about an international order, is just protecting their interests. And that's, in a way, I tend to think about these changes as a way of protecting interests from the South, from the other countries. Not only from public interests, but only private interests too, in the sense that China and Brazil, they are moving from recipients to exports of capital. So interest changed, and maybe it can be the case that this movement has something to do with this. So just to provoke thinking, thoughts, what about the Southern multinationals and how to protect investors? And China is the leading examples. Like, we want to protect our market, but we want to protect our investors abroad. And that's the main issue in IPE, and it's very hard to deal with this. And but when we talk about motivation, we have to deal with this. Otherwise, we cannot understand public policy making, and that's what I think it's interesting, and that's why we are here. Thank you. Congratulations.
Well, first of all, I'd like to thank Michelle and Fábio for inviting me. I think it's quite an honor to be here, and at this momentous occasion. Thanks. I'd like to make a few comments on the book first. Can you? Is that okay? Okay. So I'd like to make a few comments on the book first, and then pose a few questions to the editors. One of the comments I'd like to make is relating to the lack of a Southern narrative. I think despite being the recipients of FDI and despite being subject to the implications of investment treaties in a more practical sense, and if there's any doubt of this practical sense, one need only to look at the cover page chosen for the book. I think that's rather poignantly captures the implications of the lack of a narrative of sustainable development and so on in investment treaties. So the lack of this narrative, I think, is rather unfortunate. And that, in that sort of background and scenario, the introduction of this book, I think, is rather welcome, and I congratulate you for that. The second point I'd like to make is relating to the awareness, I think, amongst not just policymakers and other states, but also amongst academia and students who are now being introduced to international investment law of these issues relating to development goals and so on, because a lot of universities teach investment law from the perspective of commercial arbitration, in a similar sense of how the practice of arbitral tribunals and the interpretations that a lot of times they afforded to the substantive protections given in these treaties was from practitioners who came from a commercial arbitration background. And I think that had an effect on the vastness of the interpretations and what is now alleged as a pro-investor bias. And I think that has an effect on how students perceive this field. Another issue I'd like to point out is about the genesis of investment law as well. I think part of the problem, of course, also is that a lot of these investment treaties were introduced in the 80s and 90s and earlier, at a time where there was not a lot of awareness of the meanings of a lot of the terms and provisions of these treaties. I think there's a lot of work has been done now to establish not just how states undermined the implications of investment treaties and how claims are not just credible but also enforceable, but also the interpretations of, for example, fair and equitable treatment. So at the time when these treaties were negotiated and signed, not only was there's a disbalance in terms of power, but also a disbalance in terms of the sophistication of the amount of research or the awareness of the government officials who were negotiating these treaties. And I think that's important to keep in mind, because we've come a long way since those times to today, where we have a Southern narrative. And for that, again, I think congratulations are due to Fábio and Michelle to not just bring about and consolidate these views in a single book, and therefore to bring forward and firmly establish that there is a Southern narrative, and that lines have been drawn, and that we are now aware of where our interests lie and what we want to achieve through this system. I think that was not the case in the 80s and 90s, and India being a quintessential example of that. I have had some experience of the government of India, and I have had some curiosity to begin with of how and why did we enter into some of the treaties. I mean, Vivian mentioned the Australia-India treaty. Vivian, the Indian government officials accepted a provision which allowed Australian investors guarantee of enjoyment of their profit. Enjoyment as a term which is enforceable through an arbitral tribunal. I find in today, I don't think it will be acceptable at all. I think that reflects the state of mind which has been documented. Lauger Poulsen of University College London, for example, did a study on this and has established firmly today that a lot of government officials were not aware of to what extent these treaties were enforceable and how they will be interpreted, and were only coming into this sort of mindset after claims hit them. White Industries, again, from an Australian company, that of course was a coincidence. Or MFN. MFN was not expected to be allowed to import provisions from in White Industries case, for example, from the India-Kuwait treaty, right? So a lot of these were only learned as and when we went along. And I think that's quite an important background to keep in mind when one discusses the Southern narrative and why it is important today. I'd like to pose a few questions to the editors, I think, if you don't mind. So one of the issues I think has been hinted before was to do with the notion of the South. What exactly are we referring to here? So is it development status? Is it a viewpoint towards what is our overarching objective as when we negotiate investment treaties? Is it to do with whether we are net importers or exporters of capital? And within this notion, then, how we see China, I think, is an important question, because not only of China now importing a lot of capital, but also because, unlike the other southern states, and Vivian, please correct me if I'm wrong, but China has its own personal global ambitions of asserting its economic dominance in the world, and that reflects in its policy towards not just investment treaty law, but also other fields. And so, far from being a supporter or a fellow in the global south, I think China may indeed be an antagonist towards the cause of the global south, as hinted by some of the authors in one of the final chapters. And so one of my questions leads to this question as well, and particularly now so because of the Trump administration and its withdrawals from the TPP, for example. It has led to a vacuum to some extent in international politics, and China, if it takes a leading role and if it utilizes some of its powers towards negotiating treaties with other developing states, one may see or could possibly predict that the southern narrative may flounder. And so my question therefore is, what do we understand by the South, and how do we see China as part of it? Another question that I have is something that international lawyers tend to enjoy asking. I'm not a particular fan of it, but I think it is relevant. It is to do with fragmentation of the system as a whole. So we've seen how the South has responded. We have seen different methods to which it has tried to assert its assertion on sovereignty, but we have seen it in different and varying ways. So the question, therefore, is, do we see a unified front from the South, and in what sense can that work, and how that interplays with other initiatives from the northern states, who, in your book, as you point out, is focused more on procedural issues as opposed to substantive protections. So fragmentation is definitely an interesting question in that sense. Another question I had is relating more towards what you hint as a broader attempt to transform the international economic order. I think that's a very interesting concept, and it's definitely something that I was hoping to read more on. So you mentioned that this collective push from the global South can be a founding pillar of an alternative economic order. My question is, well, how that can interplay with other fields of law, and do we observe any other a similar push from other fields of law towards such an alternative economic order? How does this assertion of sovereignty take place, for example, in international finance law, development banks, for example, BRICS Bank, and so on? I mean, can we see these examples of this alternative economic order? And the last question I had is more of a comment as well, but I find it quite interesting how the final chapter in the book is pessimistic on the overall issue, and I think that you left that open, and I'd like to take this opportunity to push you a bit towards answering that question. I think it's an important one, because they've got a point that the window of experimentation is a small one to begin with, and I don't know to what extent that is factually correct, but the fall in commodity prices, now we see TPP, CETA, TTIP, and all these other large-scale agreements take center stage. How do you counter that is a good question. And can the differences in the approaches adopted by the southern states, can they be overcome to have a more unified front to challenge this and to take advantage of this window of experimentation? Thank you.
Okay, we're just wondering how to organize our maybe not really responses, but a way to a dialogue. Maybe Vivian could maybe address the point of the Global South. I think it was the hardest author in the book that had to deal with that. And at the end, we could find a common ground in that sense. Maybe you could react on that point. And about the motivation that Adriana provoked us too. What do you think? Does it work too? The hardest.
I don't know that that's a fair thing to ask me to do at all, actually. I think, Manu, you were talking, I mean, your illustration, I think, which is an excellent one, is the question of whether China is, in fact, an antagonist to the global South. And I think, yes, it probably is. I mean, it tries hard not to be, and I think that the Chinese government genuinely believes that it is supporting the interests of the South, and that there's a lot of belief in what it talks about when it talks about win-win cooperation. But then, as you comment, you also have private interests involved, and in this context, I think we can include the state-owned enterprises, which have their own agenda when they move out into the world and do investments and do massive contracts and all the rest of it. And those interests are essentially capitalistic, which is that they're out there, like every other investor, to make money. And since China is now becoming one of the greatest investors in the world, their objective is to make money, to buy assets, to have security for those assets, and to continue to hold those assets. So in that sense, the economic interests, which are China and its investors, are not in line with the interests of very small southern states. But I have to say that this probably also applies to Brazil in its capacity as an investor, because Brazil is also making some of the very large acquisitions, for example, in land in developing countries, which are something which is not necessarily, in fact, often not in the interests of the people whose land is taken. I mean, in terms of actually trying to define the global south, it's not something that I would, in my capacity as someone who comes from a developed country, ever actually venture to do out loud. So I should probably leave that to someone else. I did, however, want to respond to another issue which came up, I think, from the owner, which is, we've talked a lot about arbitration, but in the book we didn't just talk about arbitration, because arbitration is the end of the process. And what it represents is the failure of the treaty to actually strike a balance between the ability of a state to maintain control over its domestic agenda and the interests of the investors. And part of that is because, as you point out, of drafting, states didn't know what they were signing, etc., etc. But really, I think treaties are a really very large example of the law of unintended consequences, which was that no one had ever taken any action under the treaties, so everybody thought it was just fine to sign them. It was just like when someone comes to town and they sign a memorandum of understanding. Oh, let's sign a bilateral investment treaty, and off we go. Yeah, a photo op. So I don't think that people can be completely blamed for the fact that they didn't know how they would be interpreted. And as you say, and as part of it, I guess this is something we can address, because there is no one single way of doing it, then you have all of these various arbitrators, not just commercial arbitrators, but academics, who are reading them with a very fine line. So anyway, I think I've answered my question.
Okay, so thank you so much for all these reflections. We don't have answers to all the questions, I think, but I think we have some further thoughts on some of them. So I'll just pick some of the points raised, and then Michelle can jump in. So on the idea of that Eli brought about the idea of so back to the point on the South, and how much reform is really coming from the South. And I think there is, from the chapters and from the countries that we have worked, I do think that there's something very genuine coming from the South that is not only reproducing let's say, the demands in the North. But I do, at the same time, I think that the system is problematic both in the South and in the North, but for different reasons. So in the book we say that in the North there is a more of a concern about the procedural issues, right? Where ISDS seems to be the real problem. If you go to the North and if you discuss with in conferences, it doesn't seem that, for instance, issues that are very problematic to us, like policy space, is really what they are concerned about. So ISDS is one place where there is consensus, and that's very difficult, right? Where the system is, let's say, there's a flaw in the system, right? So, and I think I understand of the pessimism that is present in the last chapter of the book, but I do think that this, let's say, general discontent with ISDS, I think that's a window of opportunity for change, right? Because if you think about Europeans trying to reform it, they want to promote an investment court. There is a lot of discussion about that. But even the Americans, who have never lost any case are also trying to reform the system, or at least the ISDS. For the reason is that they're saying that the legislation in that country is being chilled because of the threat of being challenged in an arbitral tribunal. So I think there is, my point is, okay, there is something that is southern, as a southern narrative here. Of course, this is this narrative. I think we never meant it in the book to say that there is a one single narrative, that all these countries fit into this narrative. But I do think that there are elements of a narrative that binds these countries together, right? And I do think that the debate about the policy space is really central to the countries in the South, because if you think about them and if you look at the data on UNCTAD, for instance, most of the cases, or I mean, most of the more, let's say, sought after states in arbitrations they're always, or they tend to be, developing countries. Okay, so if you think about the system and you have the losers tend to be the states, or the losers tend to be the developing states. So there's something in common among these countries that they have good reason to try to reshape it, right? The way they're going to reshape it is going to be very different from country to country, as Adriana was saying. No state is monolithic, right? And the opinions and the perceptions on what needs to be done also changes. So until the impeachment process, I thought we had a clear idea of what Brazil wanted to do, right? But now the narrative has changed, and we don't even know if all of this progressiveness that we argued that there is in this Brazil model is really going to, keep up. So we might not even see this treaty is really flourishing. One topic that also Eli brought is this idea about, okay, if there is this common narrative, or if there is this consensus, and then I would repeat what he said, is that consensus even desirable? I don't think, differently from other regimes in the economic, in thinking about economic governance, I'm not certain that let's say a multilateral regime is what we need to have, or what we are asking for. I think that's an agenda that is very present in UNCTAD, and if you read the preface to the book, I think there is this underlying idea that, okay, now we're ready for reform, and there is this agenda behind UNCTAD that I personally don't necessarily buy, and I think what the richness of this project is to really illuminate on different narratives that different countries have on international law. So if you think from a more post-colonial perspective of international law, and if you think about changes coming from countries that are in the periphery, I think it's fantastic to see that these countries have the ability to engineer different ways of thinking about the law. I think our claim here is not in the sense of, okay, we have this single narrative, now we want a different treaty system. What we're saying is, okay, these are all these different narratives, and we want to be present in the debate, and we want at least that some of our demands are reflected in the global regime in the making. Maybe that's naive, but I think it's our first attempt to, put our feet on the door, as we say in Portuguese. Okay. Yeah, on Adriana's point on this motivation, maybe. I think if we're thinking about why these changes have happened in countries like Brazil, China, India, and in Brazil, I think the narrative is very present that it's not because, differently from China, different from Australia or South Africa or India, we didn't lose a case, so it was not like we were, let's say, harmed by these great amount of large amount of compensation, and then we have to change the system. I think our explanation for the changes in the regime is because our country internally has changed, right? So I mean, like it or not, but there was a lot of investment, public investments that allowed firms to go abroad. And then what we would expect and firms would expect is, okay, we need protection. But unlike what we could expect, and from our interviews, what business really said in Brazil is that they're not really wanting protection in the traditional terms of these treaties, but they wanted really communications channels within these countries. Especially, we're talking about other developing countries, African countries, Latin American countries, and they wanted to allow investors, Brazilian investors, to have access to those countries and try to not necessarily bring a complaint, but try to solve the issue. And I think that is, in my perspective, I think it's evident in the Brazilian system that the country wanted to do something different. And maybe it has to do also with the limitations that it had faced in the 90s when it was faced with investment treaties of the traditional kind. But I do think that there is something more here, is that Brazil is really maybe unaware or maybe unconsciously is promoting a different narrative in investment law, and that's the narrative of facilitation, whatever that might be. So I think we're moving away from this idea of peer protection or absolute protection, and we're trying to engineer something that is different. If you look at the clauses are not as protective as they are in traditional investment treaties. And they have other elements that try to really build up on this long-term type of relationship. So in the end of the day, I think there is this economic explanation or political explanation, but I think that the model that Brazil has designed is consistent with the country, with the history of the country, but also in trying to resist and to promote and to propose something that is different from whatever is out there. And then I'll pass the word to Michelle.
Thank you, Fábio. I'll try to be brief. First of all, I would like to say that I was very much pleased by a couple of comments, especially those that were on the background of the book. One of them was to push for more empirical work on international economic law, and that was our driving idea and methodology behind. And a couple of questions that we set for the authors on the beginning were on that sense. So I was very glad to listen about that. And also to the way that you express it, how you read the chapters, like as you could identify yourselves and new narratives. And so this is the main, I would say that was this is the main purpose of the book. Although it may be a little bit less than we would like to, I think that we are also trying to push us further, and we are glad about that. And this is why my comments go more on this idea of a methodology and the theoretical comments that you had. Most part of the debates that we had on the chapters, and now this is the first in the book, but calls us to think about categories. What is the categories that you have about all those countries? Can we replicate? Can you maybe take the example of Chile and have others together, stick to it? And so this will be helpful maybe in the future for us to organize more not so plural ideas of who is moving forward. Because in a way, we can say that everyone is trying to move forward, but in different directions or in different degrees. Why? I suppose that the motivation, Adriana really got to the core of the problem. I think that unbalanced relationship between public interest and private interest in this field is really problematic. And this is coming out now, and all the countries are thinking, developing North and South about reforms in that sense. But how to really go further beyond that? And then I think that we'll have many differences that comes with the ways that each country organizes its economy. If it's more state capitalism, or if it is a more hybrid economy like Brazil, or if it's real private capitalism, as you see, especially in the US, that is much less in European Union and in Japan. But and then we would have a lot of differences, and I think it's beyond what we can see that the enemy maybe can be in a first moment the private sector, but the private sector is really the partner of many of those that are proposing the reforms, and the same to Brazil. Brazil drafted its agreement together with the private sector, so this is not a problem, but it has to be clear that it is as it is happening. So that's why I think that the empirical methodology was really important. Is really to point the things of what is really, really happening in each country, and where we can find the points. But for sure that thinking about our role in academy, trying to get on more abstract terms the reality, this complex reality, I think that we have really a work to go further, and okay, we are taking this job for maybe the next book. I really liked very much your provocation about the international economic field and on trade and finance as well. I think that we identify us as a field on international economic law pretty recently, and it was very much debated if it should be considered a field. And I see that one of the good things that could come out, and Fábio and I fortunately had the chance to be part of this movement, is that to have at least conferences and groups that we can exchange ideas and information and our different narratives. And the Society of International Economic Law has been an important place for us to do this. And at the same time, I feel that we have a lot to do in this field. And even to identify the differences that we see in the trade system, in the investment system, and the finance system. And I see the finance system the hardest to work with, because it's the one that law itself has not really worked well. We have a lot of difficulties in finding documents, actors who are really the actors that are there or are behind each agreement or each project. We are struggling with that in the case of China now. So maybe it's a work that we could try to, is really to identify what didn't really go wrong in certain fields like the international investment system and the way that it was crafted in the beginning, those agreements and the international arbitrations, and thinking about not only the rules, but as you mentioned, how the field was built itself, like based on the international commercial system, and thinking mostly about the private sector in detriment of all the policy space of the countries, or even important policies such as health policy or social repression from an apartheid system that was a violence against the humanity. So these are points that I think that we need really to improve and the debate on the international economic system. So thank you so much for the comments, and we are open for the questions. For those that came later, we've mentioned that if you do prefer to prepare your questions in Portuguese, we can translate to the English-speaking people here. Thank you.
Okay, thank you. First of all, my apologies for this unlucky circumstance here. The municipality is doing some renovation in the streets. It's totally unpredictable, and unfortunately, it's a little bit disturbing, I know, so my apologies. If you allow me, I'll have one brief question. It's regarding Brazil's current kind of controversial and, in my opinion, undemocratic request for full membership of the OECD. Luckily, this candidacy seems to be paralyzed by American resistance, but not only American, the Europeans also have reservations. But I would like to know what would be the consequences for Brazil current legal environment, here investment environment, in case this full membership proceeds, in case we have progress on this. This would probably, now I'm making a statement, I'm sorry, yes, could this perhaps impede a southern alignment or coordination with regard to this subject? Yeah. We take, okay.
Okay, so good evening. My name is Bruno, and I first of all would like to congratulate Michelle and Fábio. I already did this personally, but now publicly, for this excellent book. And I would like to make just a quick provocation that I haven't had the opportunity to make before. And that arose a little bit more clear now after the provocations of Eli and Adriana regarding the concept of Global South. And also this question is also stimulated by the debates we've been having in the FGV groups, in the critical approaches to international law group and China group. So for me that I'm not from this field of international investment law, so it might be a simplistic idea, but it's how I perceive this construction of this narrative that you suggest in the book, that it seems that there is a duality on the table, that on one side we have this neoliberal project that relies on financial institutions such as the Bretton Woods institutions and, as Fábio mentioned, in procedures. And in the other side, we have this group of countries that turned themselves to the inside. So they try to contemplate by proposing those new narratives in international investment law their own national interests. And when Eli brings this discussion regarding the agency of those countries or the capacity to promote a change by proposing those new narratives, I wonder, and it's inevitable to go back to the concept of Global South, and I wonder if those narratives contemplate also other subaltern countries, okay? Because I was thinking that when you talk about the Global South community, or not a community, but about countries that belong to this concept that you call Global South, I wonder if India is Global South, what is Bangladesh? You know, if Brazil is Global South, what is Paraguay? If China is Global South, what is, I don't know, Tibet? No, Tibet's next to China, but other small country in Asia that has pretty much no voice that we can hear of. My question goes in this way. When you talk about Global South, whose voices are contemplated in this narrative, and how could they become part of this attempt to build South consensus, as mentioned by Eli, as it seems that those countries that you contemplate in the book are countries that are quite influential in their regions, and I would say that they many of them are in a very good position in the economic order. So this is my little provocation, but it's just thanks for.
Thank you. Good evening. I would like to congratulate the authors to have this initiative. I believe it's quite important to Brazil to think about investment and to think about the future of the international economic law. When one thinks that 2 years ago the international investment law and international trade law would follow a path of mega regional agreements, and nowadays we have the Trump administration trying to suffocate the WTO and trying to become to take initiative on bilateral agreements and going away from the mega regional agreements. I would like to ask you and to further question about the situation of what we could expect from the future. What is the next? And my thoughts are based on one of the Elise provocations about the role of China in this process, and what we as a South country could expect from let's say the main players of the international trade relations, international economic relations, as United States, European Union, and China, to carve out the international economic system.
So, good evening. The name is Arthur. So, first of all, I'd like to congratulate Michelle and Fábio. And actually, have just started to read the book. I've downloaded it from internet right now, so I've read only 25 pages during your speech. But the things that, as far as I have read the book, the things that maybe you are pointing something interesting that happens in other areas of international law. I mean, you're saying that the Global South is not changing or reinventing the wheels. So in the introduction chapters have mentioned that idea. And so it's not that the Global South countries, they are changing the investment rules. They are just playing according other rules. I mean, there is this now neoliberal rules from these North countries, but they have also, but Global South is not changing the structure of international law. They are just playing by ancient narrative or ancient discourse of sovereignty. So this neoliberal and so another investment area, so new discourses in international law, new narratives in international law, and global South countries, maybe they are dealing with the traditional structure of international law. And I'm thinking that this might be a mirror of another era's problems. So I would like to mention, when you think about outside investment law and you think about the use of force, and I think that chapter 7 of the UN, when you say, it's not related to investment law, but when you think about responsibility to protect the use of force, that Australia, United States, France, and United Kingdom accepts the use of force for the protection of human rights, there is this new discourse that says that North countries, they can change the rules. And the South countries the global South countries, they are saying that, so, hey, wait, we have to stand by the rules from UN Charter. So, maybe what you're seeing in this investment law in your book, I have only read 25 pages, so I have to read more. But I just had an insight that maybe you're just showing that in different areas of international law, investment law, or use of force, human rights, and other areas, we are having this clash or this conflict between maybe global North countries that are trying to change or establish a new path, and maybe global South countries saying that we have learned the rules that you have taught us, and now want to change it. So we learned sovereignty, we learned no intervention, we learned equal terms. But then, when we have finally achieved these rules that you have taught us, global South countries say, North countries say that they can now change the rules. So I think that you're just presenting a more dramatically structural change in international law, not only in investment law, but also in different sides of international law. So that's it.
Obrigado.
Okay, maybe I can pick some of the comments on that. I will start with Bruno because I was thinking about you commenting on how hard it has to us to think more in abstract terms and really trying to find the categories. And then we are really trying to get in touch and to think from more critical approaches to international law in a way that if there is this backstage of thinking about struggles, in a way that we can identify these struggles and the limits for those struggles, but at the same time try to think in a more abstract terms. And I like it very much the way that thinking about you, Arthur, and your work, not only as a professor of law, but with drama, that maybe the way that we use the word of South here is not only a rhetoric word, but is a more dramatic word. It's really trying to call the attention for the struggle, or at least to narratives that are not taken into account fully. Because even for the case of Chile, that Rodrigo went very well in describing how it has been acceptable when there is no hard questioning inside Chile about the BITs and their signature, but the fact is that they are not public, and so it's not a transparent foreign policy. So, and it's good to see that, at least. And then to answer to Bruno, I think that we are trying to have this critical approach. At least we will be able to see that, yes, there are actors that are playing the game, others that are in the bench, and others that were even called to the game. And this is a fact of international relations. But I think that if we can point that out, and for example, Vivienne was commenting on cases of Chinese investments in some countries around Indonesia, Sri Lanka, for useful things. So I think that our role, at least as academics, is to tell those stories to the world. And then their forces will be built politically. That's a reality. So I don't know if you want to go to...
Okay, so we won't answer the OECD question because we're... Okay, so we're getting to your question. So the OECD project... Yeah, so there are, of course, there is this new thinking in Brazil, right, and trying to and arguing that Brazil cannot govern itself, and then it needs all these international institutions who will be able to tell what is best for the country. That's an idea that I don't actually agree. But in case Brazil is one day accepted to the OECD, it's very likely that it will have to abide to this standard bilateral investment treaties type of approach, because the origins of the bilateral investment treaties comes from the OECD. So, and then in that case, the scenario would be of Brazil just letting go of these alternative ways of thinking about this. I just want to maybe complexify a little bit what Bruno has brought in terms of maybe we're all driven by this perception after reading the book that each of these countries know what they want to do, and okay, this is the proposal of Brazil and this is the proposal of South Africa. And maybe the authors have misled you to believe that, into believing that. But I think it's much more complex, right? I'm working on another project that involves South Africa, and I knew very little about the country. And I was very fascinated about the narrative of South Africa in investment law, because it's a country. Reading from the agreements, when you read about the South African experience, you think of you really see a country that is struggling to change, right? To implement changes, and that they are going to exit the investment regime, and they're promoting all these radical changes that is being of great concern to foreign investors. So that was my perception before going to South Africa and before learning more about the history of the country. But then. And I think that it tags into the question of neoliberal approaches versus other approaches. And truth is that if you think about Chile, for instance, it's not really going against neoliberalism, right? And South Africa, maybe it could look that way, but if you learn about the country's history, the country is based on, it depends so much on foreign investment that there's no way that it can behave differently. So if you, that is to say that within each of these countries, there is this internal limitations that although the laws and the treaties that they're promoting look differently, if you think about the reality of those countries, change is not going to happen, and not because of the external factors, but in some cases much more because of the internal limitations of really promoting something different. Because they're so tied to the system, and they live out of the system that is killing them, that is suffocating them, right? So it's a dilemma that I think it's really hard to capture, and I think there are reasons to be even more pessimistic. But I wanted to say something else on Arthur's point on the sovereignty and how these countries are using international law to the old way, the old-fashioned international law, right? And I think in some cases that is true, but I also think that the way that these countries are using international law is also emancipatory, right? Because you can think about using international law as a way to oppress, And we know it from critical approaches that you can also use it to, bring changes. So I do think that that some of these countries are using the language to promote change. So I do think that this is true. I don't necessarily think that. I still think that even though it's using the language, so let's say the jargons and everything that comes with that, I think it's also. I do think that there is innovation there. I do think that even in the case of Brazil, because we have presented this Brazil chapter elsewhere, and they said there's nothing new here. You're just copying, from other countries. You're copying from other era. So you're way back in the 1950s. But I think I can still see innovation in the way that Brazil is combining these different, let's say, different pieces of because to be quite honest, I mean, we're in 2018 and we know this regime for the 60 years. I mean, what type of change is really possible there, right? So reinvention of the wheel is really hard. So still, I think there are other ways to perceive innovation that we should value. Yeah, and the global South comes back. Yeah, I do think that there's no clear-cut answer here for what is the global South, but it is true that. This perception, and we have received this criticism. Okay, you're talking about reinventing or reconceptualizing investment law from the global South, but you're really focusing on the BRICS countries, right? On these emerging economies. So, and then the reality from Brazil or India is quite different from the reality in, I don't know, Bhutan or any other country that is less powerful, but not less important. In our defense, so this is not an exhaustive study, and we do think that there are some lessons, and we don't want to be colonial, okay? But there are some experiences, let's put it this way, that can be in the advantage of other like-minded countries or other countries that feel that they are in the oppressive side of the system, and that maybe they can make use of some of these, let's say, tools, but I do recognize that it's much harder for a smaller country that has no voice in the system and has to accept all of these conditions to really change. But maybe I don't know. I do think it's a step forward, and after all, despite the closing of the book, I'm quite optimistic. So.
Well, I guess that leaves me taking on the question of changes to the international economic system and international investment law, which I think is a very difficult question to answer because international investment law is not at all like international economic law in the sense of trade law or even intellectual property law, because it doesn't really have something like the WTO or the international intellectual property agreements to hold it up. So there's, I think, a sort of increasingly small body of public international law which relates to international investment, which is really sort of under threat from all sorts of sides. You could perhaps, when I did law, we talked about there being rules relating to expropriation, which were the developed country rules, but those really have been nibbled away at by various other countries. So you couldn't say they apply. China refuses, with the exception of the treaty with Korea, to agree to customary international rules of international law entirely. So international investment law then becomes essentially the aggregation of all of the 3,000 investment treaties and the interpretations of the various cases. And all of that, of course, is subject to the rules in the particular treaties. So as to how the whole field then develops and becomes a consolidated area is something which has been baffling people for a long time. I mean, in a way, you could say that agencies like UNCTAD are probably doing more to create the new system of international investment law than any individual country, because they're just working away quietly trying to establish principles for investment policy making, the core principles for sustainable development and so on, which may ultimately end up with something which is closer to the global south and a version of investment law. There are certainly multilateral efforts at the moment. We had China with the pushing off with the G20 principles of investment principles, which, as the Indians comment, I think actually look very much like a sort of a traditional investment treaty. Now we've got the new initiative for investment facilitation, in which Brazil is, of course, a leading actor, which establishes sort of general principles of making it easier for people to invest all over the place. But if you looked at any sort of international consensus, I don't think there really is one. I mean, the US has laid out its principle a long time ago as to what it wants. It wants its bilateral investment treaty, and it's had a lot of influence, the form of that treaty, but it hasn't actually succeeded in getting a lot of people to sign it. Because they've only got 35 treaties. They've never managed to get China to sign it. But they do have sort of forms of their investment treaty in NAFTA and in its free trade agreement with Australia, for example, and also in the Trans-Pacific Partnership. Although, as signed by TPP 11, there have been some modifications to that. The EU are playing around with the investment court along with Canada. The UNCITRAL is leading this discussion on investor-state dispute settlements. So what does the future hold? I don't know that the future does hold a consolidated international investment law system. I think it's going to be employment for lawyers, academics, and randoms for the foreseeable future, which I guess is probably very good for all of us.
Just for the sake of conclusion, I think that we are trying to reform investment, a system, and reform can mean that you break the walls and rebuild anything, but reform can also mean that we're just painting the walls and changing the pictures, and maybe that's the version which is prevailing, that reform is just painting the walls and changing maybe a bookshelf. And what I fear, and I'm more on the pessimistic side, is that this window of opportunity for reform closes with a North consensus of this cosmetic reform. But nonetheless, that being said, I'm obstinate to keep studying the South. I mean, and I'm convinced that these countries are the outliers. Empirical evidence has it. Those countries in the book are outliers. Most countries, and responding Bruno, are out of the game, as Michelle just said. So we have a lot of work to do, just like our mates out there trying to reform the street.
Thank you all for your time here and for joining us in this debate. And thank you so much for Vivian for coming for so long. And Manu, who is joining from his southern perspective, Adriana and Eli, that we hope to keep discussing and bringing new ideas together. Thank you. Thank you all.
And for those who were really truly instigated about our discussions and want to buy the book, we do have a let's say code for those interested, discount code. I think it's 20% and it means a lot, right? So come talk to us if you're interested. Thank you so much and glad to see you here.
Yes, that's another hard part of this work. This book was published by Cambridge University Press. It's pretty expensive, and we know that's inaccessible for most Brazilians and in other countries that we are talking about. And but anyway, to publish in a publishing house as Cambridge, we have to start with a hard copy first. And we are beginners in this world, and so we, for sure that our contracts were not so good as other Americans can get. We are trying to work hard on that. That's what we can get is the 20% discount, but the most that we sell, we can go to the paperback. Okay, so thank you so much.